Welcome to Law, Life, and Liberty with Anthony Puopolo.
Welcome to Law, Life, and Liberty with Anthony Puopolo. Anthony G. Puopolo II is a Massachusetts attorney who helps families navigate divorce, custody disputes, and criminal charges that often overlap. With offices in Lowell and North Andover, he represents clients across Middlesex, Essex, and Suffolk counties in both family and criminal courts. I'm Lisa Mosby, and today we're talking about navigating domestic violence allegations during a divorce. Welcome, Tony. Thanks so much for joining me today.
Thank you, Lisa. Nice to see you.
Yeah. Tony, in your years of practice, how often do you see domestic violence allegations emerge only after a divorce filing? And why is that timing so significant legally?
I would say because of the nature of what I do, I see it very often, and it does substantially complicate the beginning of any kind of proceeding because it leads to some speculation that the allegations may be false, that they're very conveniently timed, but there's also the other side of the coin where often domestic violence is the precursor to a divorce. And it's just someone reached their limit and said, well, I've never talked about this before, but it's been going on. So it does make the case substantially more complicated in trying to parse the facts from the lies.
I can understand that. Without naming names, what is the most important lesson you've learned about the human side of representing clients who are dealing with these life-altering accusations?
Well, I would say that it absolutely devastates lives. It will devastate your children. If this is something that you're thinking about making an allegation just because you want to get the leg up, don't do it. It will destroy your children. And it will destroy the other person's reputation and their life. I had a client who, after 2 years of litigating, he was found not guilty of the domestic violence charges. They actually came out that she had essentially lied, and he lost his job as an educator, and he hasn't worked in years in the field of education. So these are very, very serious allegations, and they will ruin lives.
And how does the pending domestic violence charge impact the statutory presumption of custody in Massachusetts?
Well, there's actually another statute that says that if there is a history of domestic violence, it is presumed not in the best interest of the child that the abused parent share custody with the abuser. It can lead to the court will have to consider a variety of things to do to ensure the welfare of the children and the abused parent, including, pickups and drop-offs at police stations for parenting time or supervised visitation. There are a lot of things that will impact your time with your children while these allegations are being sorted out.
And then, Tony, can a judge issue an emergency order to remove a parent from a marital home based solely on an uncollaborated allegation?
Well, it depends on if we're talking about a restraining order versus what we call a sole use and occupancy order. In the family court, the court has the authority to grant sole use and occupancy of a home to one or the other person in a divorce. And an allegation is a form of evidence. So the standard in the civil side of courts is preponderance of the evidence, which is essentially whoever gets slightly over 50% is the winner. If one side says that the other side is abusive, that person denies it. If there's any other evidence at all that can corroborate one story versus the other, that person is likely going to be the person who will win. So yes, not completely uncorroborated, but if they have anything that supports what they're saying, they can get an order to remove the other person from the home.
And then how do you handle tactical restraining orders where one party may be using an allegation primarily to gain leverage in a custody battle?
It's really important to analyze the entirety of the relationship with your lawyer before the restraining order hearing. So in Massachusetts, you don't have to have all of your allegations in your affidavit. It would be great if people did, but that often isn't the case. People will come to court with more allegations than are in the restraining order affidavit. So it's really important for me when I meet with my client to tell them, look, I need to be prepared for every possible thing this person might say. I want to know that day you were arguing over text. I want to see the text messages to see if they could be cropped to make it look worse than it is, because often that happens. So it's really, really important to be open and honest with your lawyer and to really talk about all the nitty gritty of the relationship as much as humanly possible to be able to be prepared for that hearing.
And I'm thinking of physical evidence. You mentioned text, but if there is no physical evidence of abuse, what types of circumstantial evidence, maybe emails or witness testimony, do courts find most persuasive?
Well, so emails would be direct evidence.
Okay.
Realistically, hearsay is incredibly relaxed in a restraining order hearing. It's very freely admissible as long as there's some reliability to it. The courts are not just going to let in any statement at all. But if it seems reliable, the court's going to look at it. And things, especially in June of 2024, Massachusetts restraining order law was amended to include what we call coercive control. And that's things like trying to isolate your partner from their friends and family, being financially controlling, things of that nature. So text messages that involve that might even be completely innocuous. I had a client who had a restraining order issued against him where he would routinely ask his significant other to share her location via iPhone. Don't be that couple. Don't do that, because even if you think it's completely harmless, it can be used against you later, and it can be made to look like you're controlling. Don't do it.
And then if a restraining order is granted, how does that specifically change the service of process and communication rules for the ongoing divorce?
Well, I think it largely depends on which court issues the restraining order. If you are in the family court, the court will likely put in orders about how you will communicate. There are apps that we use. Two common ones are AppClose or Our Family Wizard. They're essentially apps that allow you to communicate, but they cannot be altered or edited in any way. The family court will often order people communicate through those. But in terms of any kind of service, you should be letting your lawyers do all of that stuff. To the extent you're representing yourself, you will need to ask the judge to allow you some means of service on the other side if they are also not representing themselves. So I would suggest if this is issued by a district court, not the family court, then you should ask the judge to include in the notes of the order that you may have communications via either one of the apps that I just referenced for the purposes of facilitating the divorce process. And if there's children, you can ask the district court judge to allow communications over that app solely as it relates to the children, but they'll generally be hesitant to do that and tell you to take it to family court to be modified.
And then, Tony, can an allegation of abuse from years ago that never resulted in a conviction still be used against a parent in a current custody hearing?
Absolutely. Although I would say the more remote in time, the less credible the allegation becomes. But I had a restraining order a couple of years ago where the domestic violence incident in that case had occurred 4 years before that. And the judge said 4 years is not a whole lot of time. So realistically, a history of abuse is a factor that's relevant in the judge's determination of whether or not there's a current need. The standard here is that there needs to be imminent risk of bodily harm. So the court is going to need to find some current risk, but a history is relevant and the judge will consider it.
And Tony, where I want to wrap this up today is one final question. How can a parent protect their reputation and parental rights if they are falsely accused during a high conflict litigation?
Well, I would say there's definitely two parts to that question. Let's start with protecting your reputation. Rise above the allegations. Don't sling mud. Just deny that you are the person that they are claiming you are, and just proceed as rationally and civilly as possible. If you start slinging mud, you make yourself look like the person they're claiming you are. Now, let's look at part 2, protecting your parental rights. The first thing you should do, if this restraining order is issued outside of family court, you should get into family court as soon as humanly possible. You should work with an experienced lawyer who is familiar with these kinds of cases, because generally, unfortunately, parenting time is not considered an emergency, so it doesn't allow you to, jump the line and get into court quickly. And some judges, their motion dates are months out. So if there's a potential for a lawyer to file this as an emergency, you want to do that so you can get into court as quickly as possible. But the first thing that you need to do is get to family court and file so that you can have some parenting rights restored if the district court stripped you of them.
Anthony, that's where we'll leave it today. Thank you so much for your insights once again this week. Folks, that's it for our episode of Law, Life, and Liberty with Anthony Puopolo. To learn more about Anthony G. Puopolo and his work across Massachusetts family and criminal courts, visit agplawoffices.com. Thanks for listening, and don't forget to subscribe, share, and leave a review so more Massachusetts families can find the guidance they need. And we'll see you next week.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.